Okay, we are now live and on the record for Monday morning civil docket, February 28, 2022. Mr. Damian Orozco, what do you have?
Good morning, Your Honor. I have number 16 on your civil docket. That's Jose Luis Renteria and CO 195753I, Your Honor.
Okay, that is versus USDA Rural Development. Is there anyone on the other side?
No, Your Honor, I didn't see anyone on your docket named for them. And today you were not asking to finalize it, Your Honor. It had been a while since I had contact with my client. He finally responded to a letter that we sent to him last week. So we're asking for some more time on it so I can contact opposing counsel, Your Honor.
All right. How much time are you requesting?
30 days, please, Your Honor.
Okay, April 11th at 9:30.
Thank you, Judge. That concludes my business, Your Honor. May I be excused?
You certainly may.
Thank you, ma'am.
Okay, Mr. Velasquez.
Good morning, Your Honor. Happy Monday.
Happy Monday, sir.
Thank you, Judge. I have number 12. I have 3 cases. Number 12 on your docket.
Okay, CL 196530-I, TD Auto Finance et al. Versus Carlos Quintanilla.
Yes, Judge. And plaintiff is requesting just a default judgment date so this can be heard. I do believe that all the proof of documents have been previously filed with the court.
Okay, was there an order setting hearing that was filed with the motion for default judgment?
Judge, I don't want to mislead the court. I don't know for sure. I can check into it to see if it was filed, and if not, then I can instruct the client or the attorney of record to make sure that is filed with the court.
Okay, go ahead and get that on file, and then we'll set that administratively.
Your Honor,
Okay.
if I may.
Go ahead.
Judge, the default judgment is set for this morning. However, there is no motion or order granting that motion filed. That was the purpose of it being reset from January the 12th, I believe.
So plaintiff needs to file the motion for default and a proposed order.
Okay, I'm sorry. So it
was set, Judge, but there was no motion. So therefore, Your Honor did reset it. There was an order resetting that was refiled, Judge, but the motion was never filed. So please.
Oh, so they requested it off the bench, and then I went ahead and gave them a date, but they didn't file the motion. Okay.
Yes.
All right. So you need to file your motion for default judgment and the order setting hearing.
An order setting hearing. Yes, Judge. Okay, thank you. The last 2 I have, Your Honor, are 37 and 39 on your docket sheet.
Okay. CL 190195-I, Cascade Capital versus Epigmenio, EPIGMENIO, Cerda et al.
Yes, Your Honor. And we are simply requesting a trial date from the court.
Okay, Mr. Ramirez, is Attorney Dennis Ramirez here? Okay, so are you going to be asking for a bench trial or a jury trial?
A bench trial, Your Honor.
Okay, go ahead and file an order setting the bench trial, and we'll get that set for you. Make sure opposing counsel is CC'd on that.
Yes, Your Honor.
Okay, and then you said number 39?
And number 39, and it's the same announcement, and I suspect it's going to be the same request to file the order setting hearing.
Okay, CL 191630-I, Capital One versus Ira, EIRA Jimenez. Ira Jimenez, are you present? Ira Jimenez? Okay, so you want that set for a bench trial?
Yes, Your Honor.
Okay, file an order setting the bench trial and we'll get that set for you.
Thank you, Judge. And Ms. Rivera, can I inbox you? I have 3 other cases that I don't believe were on Judge's docket to see the status of those cases.
Absolutely.
Okay, thank you, Judge. That's all the business I have before the court. May I be excused?
You certainly may.
Thank you, Your Honor.
Okay. Ms. Karina Murillo?
Yes.
Okay, you said number 17?
Yes, ma'am. Morning.
Okay, F 3222-21-9 in the matter of the marriage of Karina Murillo versus Jesus Alvarez.
Yes, we were missing the standard possession order. I couldn't turn it in by itself, so they want me to file everything again. I just wanted to see if I can get a couple of days so that we can sign it.
Okay. The earliest I have is April 11th at 9:30.
That's perfect.
Okay,
Thank you.
you're very welcome.
May I be excused?
You certainly may.
Thank you.
Yes. Okay, Mr. Webb,
Good morning, Your Honor.
good morning.
I'm here on number 14, CL 16 3227-I.
Okay, that's Karen, Karen Romero versus Marcela Rodriguez.
And Judge, we represent plaintiff Karen Romero in this suit. Judge, this is a reset from a DWAP setting that you had previously put on the court's docket that was reset. We had asked for more time to attempt more, to try more attempts to get a hold of the defendant tortfeasor for service of process. Just to recap briefly, Judge, so I don't take much of your time. This is a DWAP because the insurance company that we had been negotiating with, Affirmative Insurance Co., had gone bankrupt. And Texas Property Casualty Insurance and Guarantee Association had taken over the claim file. They imposed a new restriction for negotiating or even providing a defense in that they needed the tortfeasor insured to contact them and request a defense. So we had made several attempts via email, both regular and certified, to make contact with the defendant to no avail. We also sent our investigator to all the addresses that we were able to find, to even speak with some of the neighbors to try to find to ascertain the location of the tortfeasor, but we've had no success, Judge. And so I understand the court's need to put it on the DWAP docket. We had asked for more time previously to make more attempts, and those attempts were made to no success, Judge. So I'm just reporting to the court.
Okay. Well, I mean, how else will you be able to prosecute your part of the case? So, I mean, is it feasible that you're going to find them, or?
I can't make any promises to the court that we're going to have any success since the attempts that we've made. We've, in our mind, in our zealous advocacy for our client, have tried everything that we thought possible and have not had any success. So I can't guarantee that we'll have any success in the future, Your Honor.
Okay. Okay, well, I mean, how else would we deal with it? I don't have a choice but to, if there's not a way to go ahead and move it forward, that's the whole point of keeping it on the docket, is if there's going to be able to be some kind of progress and you're going to be able to move forward. So if we're not going to be able to move forward on this case, and I'm not going to have any choice but to just go ahead and dismiss it.
And
But
I understand, Your Honor.
I don't know, unless you want to speak to your boss and see if, I mean, so you all don't want to file a dismissal? Or do you, based on the fact that you can't find them?
Correct, Judge. I mean, we had, and that's for the reason we had asked for more time. The last time I was actually in front of Your Honor on this same case, we had asked for more time for that same reason, to try to attempt more, send our investigator out and to try more. We had some success getting a hold of the neighbor who had told our investigator that there was that the person we were after was still living in the home. We'd even attempted to send text messages from the neighbor's phone to the tortfeasor to try to make contact. Nothing came from that. Nothing came from those attempts. So we really don't have anything else to report to the court on that. We do obviously want to try to zealously advocate for our client's best interest, but we've been unsuccessful thus far getting a hold of the tortfeasor. And because TPC IGA is not going to negotiate or defend the case without that tortfeasor making contact with them and requesting that defense, we've really kind of hit a brick wall.
Okay. And so I don't have any other choice than to just dismiss it. And I can understand why you all don't want to dismiss it, but I can't have it on the docket if we're not going to be moving forward with it.
And I understand,
So-
Judge.
Okay, well, I'm gonna have to dismiss it for want of prosecution, and if you need me, if after speaking to Mr. Salazar and you need for me to reconsider, just go ahead and file a motion to reconsider, okay?
We will, Your Honor. Thank you, Judge.
All right, thank you.
May I be excused?
You certainly may.
Thank you, Judge.
Okay, Mr. De Luna,
No, sir.
Good morning, Judge.
good morning, sir.
Judge, we're set on, it's number 24 in the docket.
F 2527-15-9, in the matter of the marriage of Manuel Salazar and Minerva Maldonado Salazar.
I looked at all that already.
Your Honor, Sofia Rispe for Minerva Salazar.
The
Okay,
reason I raised my hand, Judge, is I just want to see get some direction from the court. This is gonna, it's set for a final hearing that I know they're probably gonna need testimony and vice, and, you know, from both clients and back and forth, and it won't be an agreed final divorce hearing, so I just don't know what the court would like to do on this case.
okay, so let me ask y'all, so this is an original divorce that's been on file since 2015?
Correct, Judge.
Thank you, Judge.
All right, and so have y'all worked it up to have a final hearing?
I'm
A
pulling
contested
up
final
like
hearing?
another case whenever the court-
Judge,
Well,
last time we were before this court, Judge, this case was transferred from the 92nd District Court, Judge. And the court ordered us to go back to mediation because it'd been a long time since we had mediated this matter. I know that my staff spoke to Mr. De Luna's staff. I didn't know the court was gonna appoint a mediator, Judge, or if the court wanted us to find one by agreement.
And I believe Ms. Diana Fuentes Aguilar.
And I'm fine with either one. I'm fine with either one, Judge. I mean, if the court is amenable to just giving us a mediator, and the only thing I would ask, Your Honor, is that the mediation done, let's say within 30 days, and then have a final setting at that point, because we're really trying to get this case resolved, Judge.
Okay, so do you all have can you all agree to a mediator?
Whatever the court feels is fine with me, Judge.
Okay. Let me go ahead and have you all just agree to a mediator. I mean, you both are seasoned, you can talk about it.
Okay.
And so agree to a mediator, mediate within 30 days. And then, now let me ask you, are y'all wanting for me to do this contested hearing, or are you going to be filing a jury trial?
I'm fine with Your Honor making the decision at the end.
And we are too, Judge.
Okay, so go ahead and do the mediation within 30 days. And then what we're gonna do is we're gonna have
Make
a
sure you
DCC
submit, the order says that by agreement of the parties.
Yes, Your Honor.
on April 1st, so we can set you a DCC on April 1st
Okay, Efrain, what do you have?
at 10 a.m.
Okay.
And it'll be just so that we can come up with a
Do you
date
need
that
to-
everybody's available for a bench trial.
Yes, Your Honor. And
Yes,
I'll
ma'am.
get with Ms. Rispa, and we'll agree to the mediator and hopefully get it done within the next week or two, Judge.
Okay, sounds
Sounds
good.
great. Thanks
May
a
I be
lot, Judge.
excused?
Have a big excuse.
Yes,
Okay, I see
thank
it.
you. Okay, Mr. Richard Flores, I think you're on a plane, is that correct? Okay, what case do you have, sir? You're on mute.
Okay, yes, so it's a divorce court. There's my ex-wife, so we're good.
Okay, who's with Mr. Flores?
I am.
Me, myself, and I.
Okay, Letty Flores, okay,
Yes, Detective Flores is my ex-wife.
okay, hold on. What number are you, do you know on the docket?
Number 20.
She would have that
Okay.
information.
All right, so then, I have that the OAG filed an intervention.
Yes.
Your Honor. Good morning. Elias Alcantara, with the Office of the Attorney General.
Okay, and Mr. Alcantar, on your part, is it ready to be finalized?
Your Honor, I did see that they submitted a proposed order this morning. I have not had a chance to review it. I am going to be asking for more time to review the proposed order, just to make sure everything's okay with
my
it on our
wife,
end.
my ex-wife and I have come up with a care plan, and we have come up with multiple documents that have established the extension between her and I. So I don't know if you're needed for the judge to make a final decision. But we
Yes.
have come up with the care plan. We have come
Okay.
up with a plan of action. We have come up with my financial support to my ex-wife.
Okay,
So,
I understand
Trust
that,
is
but
not
because,
in the arrangement.
okay, hold on. But because the AG's office has filed an intervention, they are
I don't
legally,
understand what that means.
okay, they filed an intervention in your case, which means that they feel that they have an interest in your case.
Okay,
And
well, their
so,
interest is not in my interest. How can I dispute that?
well, Mr. Flores, the thing is that since they have filed an intervention, they are allowed legally to look at this case. And if they feel that they still need time, which is what they're asking for, I need to give them that time. So I don't think they'll
Yes,
need
ma'am,
that
I
much time.
understand completely.
Okay,
No,
so
it's all on you and
yes, it is. Okay, Mr. Alcantar, how much time are you requesting?
Judge, I'm requesting at least 30 days. I do want to go over with the parties as to what the state interest is as well.
Okay, so then we'll come back on April the 11th at 9:30.
Okay.
Thank you, Judge.
Okay, please make yourselves available for the Attorney General's office so that they can discuss with you what it is that their intervention entails.
Okay.
All right? Okay, you're
Okay,
both
so if
excused.
we want to attest the intervention, how does that follow?
When you speak to them, then at that time, you need to hear why it is that they're filing their intervention. If you disagree, when you come back, then that's when you'll go ahead and let me know what it is that you don't agree with.
So if both parties agree, my ex-wife and I, how does that lean towards our judgment besides the state of Texas?
Hold on,
Because
Mr.
her and I
Alcantar,
have agreed
wait.
to a care plan.
Wait a minute. It's not about your care plan. The state only gets involved if they have a financial interest. So were these children on Medicaid?
Yes.
Well,
Okay,
yes,
all right. That's why they have an interest. Because when
I
the
understand.
children are on Medicaid, then the state has an interest and they want to get paid back. So that's the problem.
I understand now. Yes, ma'am.
Okay, so
100% crystal clear.
now
Thank you.
they're gonna have to talk to you all about that. So, Mr. Alcantar, I'm gonna grant your continuance. You'll have that time to talk to the parties, and they'll return back on April the 11th at 9:30.
Thank you, Judge.
Yes,
All
ma'am.
right, thank you.
Thank
You all
you.
are excused.
Bye-bye.
The gentleman on Elizabeth's iPhone, make sure you take your cap off.
Ain't that a bit? That a motherfucker.
All right, okay, Mr. Rodriguez, number 27.
Yeah, good morning, Your Honor. This is a motion for default judgment.
Okay, CO 174843-I, Bank of America versus Gabriel Cadena. Gabriel Cadena. Present, Gabriel Cadena. Gabriel Cadena. All right, you may proceed.
Thank you, Your Honor. I would like the honorable court to take judicial notice of all the documents in file. And we are including the business records affidavit, proving all the elements of the default. We are asking for a default judgment in the amount of $16,068.42 plus court cost. We're not asking for any interest this time.
Okay, the court is taking judicial notice of all the documents on the court's file, specifically that this was properly served. Service was returned and filed on December 21st, 2017. To date, there is no answer on file. The court is granting the plaintiff's relief as requested and set forth in more detail in an order that was filed on October 9th, 2018, and that's the one that I'll ask for it to be forwarded to me. Okay, your next case is number 34.
That's correct.
CL 3257-I, First Technology Federal Credit versus Doroteo,, Espinosa, ESPINOSA, the third. also known as Doroteo Espinosa II. Okay, and what is your announcement, Counselor?
On this one, Your Honor, we are on a motion for summary judgment because an answer has been filed. I don't know if the defendant is present at this hearing.
Okay, there's somebody that's just coming in for their waiting room. Hold on. All right, Doroteo Espinosa, are you present?
Yes, Judge.
Okay, so Mr. Espinosa, you don't have an answer on file for your summary, for the motion for summary judgment. Are you requesting some time to see if you can settle this matter?
Yes, ma'am.
Okay, Mr. Rodriguez, do you have a phone number for Mr. Espinosa to call?
Yes.
Okay.
I need to look it up in my computer.
Okay, you are breaking up very badly.
Yes, I do have a phone number up on the system here.
Okay,
It'll
what's
take
the
only
number?
a couple of minutes. I'm looking for it. Hold on.
Whenever you get the number, just go ahead and put it on the record, sir.
Yeah, because I don't have it. I don't have it with
Okay.
me, Your Honor.
Let me go
But I
ahead.
have my client contact the defendant.
Well, let me go ahead and have Mr. Espinosa, can you please put your phone number on the record so they can contact you?
Yes, Judge. 956-247-9931.
Okay, Mr. Rodriguez, did you get that?
Yeah, 247-9931. Is that correct?
Yes.
Yes, I got that one.
Okay, and then we'll come back on April 25th at 9:30.
Was that the 25th?
Oh, I'm sorry, the 27th.
Okay. Very well, Your Honor. Those were the only two cases that I have this morning before this honorable court. May I be excused?
You certainly may.
Thank you. Have a beautiful rest of the day.
Likewise. Thank you, Mr. Espinosa.
Thank you.
All right, next, Ms. Madar, it's CL 20-1590-I, Geico Insurance versus Daniel Alanis et al.
Yes, good morning, Your Honor. I am here on a summary judgment motion as to both defendants.
Good morning. This is Aaron Peña. I represent Mr. and Mrs. Alanis.
Okay, and are we ready to move forward on the summary judgment?
I'm ready, Your Honor, yes.
Mr. Peña?
Judge of my clients. Let's see if the plaintiff can prove the case. My client's wife was not driving and she was not in the vehicle.
Okay, but let me just check. Did you file your response to the summary judgment?
No, Your Honor.
Okay, go ahead, Ms. Madar.
Yes, thank you, Your Honor. I would ask that the court take judicial notice of all the documents on file.
Okay, the court is taking judicial notice of all the documents in the court's file.
And as opposing counsel noted, we filed our motion for summary judgment and he has not filed any sort of response. The only response on file for the court are the answers. My office served discovery on both defendants And I'm pulling up the date here. I apologize.
Is, do they have the ability to sue the owner if she was not present?
Hold on, she's still arguing, she's still making her arguments. Go ahead.
Of course. We e-served a discovery on opposing counsel on February 2nd. And I have no responses on file yet from opposing counsel. Oh, and excuse me, it was February 2nd of 21 and not of 22.
Okay, so you sent discovery and it still hasn't been answered.
Exactly. And so we also asked the court to take notice of the attached exhibits, including the request for admissions. This case is an underlying subrogation case based on a car accident. The police report is part of our exhibits and part of the business records. The police report indicates that Daniel was driving a car owned by Olga Alanas. Excuse me, Daniel Alanas was driving a car owned by Olga Alanas, and that car rear-ended my client's insured, resulting in $14,437.34 in damage, which is what my client's seeking as recovery. Based on those damages, so we're just asking the court at this moment to grant summary judgment based on the amount of the damages, post-judgment and pre-judgment interest, and attorney's fees in the amount of $750.
Okay, Mr. Pena?
If counsel for plaintiffs, Your Honor, feel confident that they can make a case against both defendants, I'll defer to the court.
Okay, well, in reviewing the documents that are on file, I do see that an answer has been filed. However, there aren't any affirmative nor verified defenses that are on there. It's just a general denial. And there is no answer on file for the on the motion for summary judgment. And they're also, so I just want to be clear. I'm not sure if you were aware of that, Mr. Pena.
I'm aware of it, Your Honor, yes.
Okay, all right. So is that all from the defense?
Yes, Your Honor.
Okay, then I'm gonna go ahead and take that. I'll take it under advisement and I'll issue a ruling shortly. Okay.
Thank you, Your Honor.
Thank you,
All
Your
right.
Honor.
Thank you. All right, next case, Mr. McInnes.
Good morning, Judge. I've got two matters to say. They're both the uncontested divorces, number 18 and 19 on the docket. I can either do them now or stand by whenever the court's ready.
No, that's fine. Is your client on?
Yes, both clients are on, Your Honor.
Okay.
They may require a translator. I'm not certain. I don't recall.
That's the problem. Okay, hold on. What number was it?
18 and 19, Your Honor.
All right. So who may require a translator?
Both of my clients, I'm not certain if they speak English or not, Your Honor. I think Mr. Compian does, but I don't recall.
But he's your client?
Yes, he's my client. We use translators at the office all the time, Judge.
Oh, okay. So Jorge Compian, is he present?
Yes, good morning, Judge.
Good morning, sir. Do you understand English or do you prefer in Spanish?
Yes, I do. I understand English.
Okay. And Kenya Compian, is she present?
She signed a waiver, Your Honor.
Okay. Then let me go ahead and call F3398-21-9 in the matter of the marriage of Jorge Compian and Kenya, Kenia Compian. Mr. Compian, will you please raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I swear.
Okay, go ahead and lower your hand. Go ahead, Mr. McInnes.
Judge, we'd ask the court to take judicial notice of the filings on file in this case, including the waiver filed on November 9th last year.
Okay, the court takes judicial notice of all the documents in the court's file. Go ahead.
Thank you. Please state your name, sir.
My name is Jorge Alberto Compean.
And are you the same person married to Kenia Mariana Compian?
Yes, sir.
Were you married on or about March 21st, 2014?
Yes, sir.
You stopped living together as husband and wife on December 2017?
Yes, sir.
Is it true you have one child of the marriage named Yeshua Dylan Compian?
Yes, sir. That's true.
And he was born on July 26, 2014 in Edinburgh?
Yes, sir. That's true.
And he's in the primary custody of your wife, is that correct?
Yes, sir. It is.
And you're not asking for to take custody away from her. You just want visitation, is that correct?
No, I don't.
You're not asking for visitation. You're not asking for custody.
Yeah, I'm not asking for custody.
Thank you. Are there any other children expected of the marriage?
No, sir.
Do you own real estate?
No, sir.
Do you have a retirement plan?
No.
What vehicle are you going to keep in this divorce?
I got a Chevy Silverado, 2014 Chevy Silverado.
And do you know what kind of vehicle she drives?
Yeah, she drives. It's a Nissan Versa. I'm not sure what model is it, but I think it's 2012, something like that. I'm not sure.
Okay, and you're okay with you keeping your vehicle and she keeping her vehicle, is that correct?
Yes, sir.
And you were asking the court to allow each party to keep their own personal property that's presently in their possession?
I'm sorry?
You're asking the court to allow you to keep the personal property you have in your possession?
Yeah, that's fine.
And you've been paying child support since before we filed this divorce. Was it per a court order or was it voluntary?
It was voluntary. Yeah, I pay child support.
Okay, and are you still earning about $8,000 per month in your job?
Yes, sir.
Okay. And you're asking the court to base their child support calculations on that figure, is that right?
Yes, sir.
And does the child have medical insurance?
Yes, I pay for it. I pay for the Medicaid.
Okay. Are you asking the court to grant you a divorce?
Yes, sir.
That's all the questions we have, Judge.
Okay, so the child, I'm sorry, is on Medicaid then?
That's right.
Okay, and since he's been paying child support voluntarily, in what amount?
I pay $325 every week. $325 every week.
And have you been paying that directly to Ms. Compian?
No, Judge. They discount that amount from my paycheck.
Oh, okay. So that wage withholding order, Mr. McInnes, did that come from, is there an OAG case?
I'm not aware of it in general. He testified that it was a voluntary payment, Judge.
I know, but if they're taking it out of his paycheck, there has to be a wage withholding order.
Mr. Compian, has the attorney had communications with you regarding child support?
I'm sorry?
Has the Attorney General had communications with you regarding child support?
No, I'm not sure. I'm sorry, I don't understand that question, sir.
Has the Attorney General's office contacted you regarding you paying child support?
Oh, yeah, yeah.
Did they get an order for that amount to be withheld?
Yeah.
Judge, we'll go and research and find out the case number for that order and put it, put the support as per that order.
Okay, so if there's already an order on file, then what you're needing to do is find out what that case number is that's attached to that order, and you'll have to file a motion to consolidate that case into this case. And then once that's done, then you can divorce them.
So then we need to get that consolidated before the court can sign the final decree of divorce.
Correct.
Okay, we'll do that, Judge. Well, we have already provided the testimony for the divorce today's.
Right. So you've already provided the testimony. I'll accept the testimony. However, you need to file that motion to consolidate those two cases. That'll be consolidated into this case. Now, on your divorce decree, do you all have contact with her that she'll be signing off on this?
Judge, she voluntarily signed the waiver, but that's the only contact we've had with her.
Okay.
And
So the only thing that's they didn't have any community property other than the vehicles, correct?
that's right.
Okay, so then go ahead and just have at least your client sign off on it and you sign off on that decree. But nothing can be done until that motion to consolidate is filed with the order granting.
All right, Judge, we'll get that done.
Okay, all right, so Mr.
Maybe-
Compian, you're excused and your attorney will have some documents for you to sign later on.
Okay, Judge.
Okay, and then Karen Menjivar, Menjivar. Are you present?
She may require a translator, Judge. I saw her online earlier. Karen,
Okay, she's under Karen Paz. Okay, Miss Paz, English speaking or Spanish speaking?
Español.
Okay, so I do not have an interpreter available today. Unfortunately, there was a medical emergency with her. So I would have to reset you to, let me double check, just for about a. Let me see. I'm gonna have to reset you for March the 7th at 9:30.
Judge, can I check that date?
Sure, go ahead.
I might be a little bit late, Judge, because I've got 2 hearings at 10 o'clock.
Okay, well, I also have March 21st.
I'd rather go ahead and put it on the 7th, Judge, I think.
Okay, just go ahead and jump in whenever you can on March 7th. Miss Paz, ahorita no tengo alguien que pueda traducir porque ella tuvo una emergencia.
Okay.
So va a tener que regresar usted el día 7 de marzo,
Ok,
que es el próximo lunes, ¿ok?
ok.
Bueno,
That's all.
entonces va a estar a la misma hora, a las 9:30, ¿ok?
Ok, perfecto.
Bueno, gracias. Que pase buen
Gracias.
día.
Igual.
Thank you, Judge.
You're
May we be-
welcome.
Thank you. Have a good day.
You too. Okay, Mr. Rendon?
Good morning, Your Honor. I'm here on behalf of the plaintiffs for number 40 on the docket.
Okay, CO 195400-I, Juanita Silva versus Jose Luis Martinez.
Yes, Your Honor. It's a status conference on our office's motion to withdraw. There had been an issues. The plaintiff had unfortunately passed away of COVID, and the family was difficult to get a hold of. We went several months without being able to make contact. We were able to reach her husband, the widow, during this time that we were waiting for the hearing. He's still very distraught. He does not really want anything to do with the case or work on this file anymore. We explained to him the situation that if that was the case, if there's nothing that he wanted to do, there was nothing for us to do for him, and that we wanted to withdraw. We explained to him that if after some time, talking to his family, they want to pursue the case after all, they could seek other representation, but at this time there's nothing else for us to do for them.
Well, why don't y'all just non-suit then if he doesn't want to do it?
Okay, we can we can do that. We had reached out to his son as well. I know that the children are adults. They had been a little bit more cooperative in the past. We wanted to give them a chance, but if the court prefers that, we can get that done.
Well, yeah, because if not, then I'm gonna have it on my docket and nobody's gonna be able to help them. So I need for you to find out if you all can non-suit this instead so that it can get off my docket.
Okay.
So I'll give you some time to contact them again and just come back on April the 11th at 9:30.
Will do, Your Honor. Thank you.
Okay, thank you.
May I be excused?
You certainly may.
Thank you.
Thank you. Mr. Alvarez?
Good morning, Your Honor. I'm here number 38 on your civil docket. It is set for a status hearing. I represent the defendant, and this is an appeal from a JP decision. Mr. Daniel Vargas represents the plaintiff. I believe the court, in looking at the docket, has set this up for a DWAP in December, and then I guess he must have appeared, and we have a DCC coming up.
Okay, yes, I believe it was because at the time, well, as you know, a business would have to be represented by an
Right.
attorney. They can't be pro se. So that's on CL 1863995-I. Mr. Vargas checked in, but he's in the 398. Have y'all had an opportunity to talk?
No, Your Honor, I just filed my notice of appearance this morning. I did see that we have a DCC set for March 11th. He did ask for a jury, and he also paid for the fee. So we'll just attend the DCC and get it scheduled.
Okay, that sounds good. I'll have my staff let him know that we'll just do the DCC and move forward.
Thank you for your time, Your Honor. Have a good morning.
Thank you, likewise. Take
Bye.
care. Mr. Fernandez, Attorney Robert Fernandez.
Good morning, Judge. I have 21 on the court's docket.
F 4090-21-9 in the matter of the marriage of Monique Galvan and Jose Galvan Jr.
Yes, Judge, I want to just prove up the divorce.
Okay, I see Ms. Galvan on. Was Mr. Galvan also going to join us?
I believe he is going to join us.
Mr. Galvan, are you present? Okay, you're on mute. Unmute yourself, please, and Ms. Galvan, please unmute yourself. Okay, can you hear me, Ms. Galvan?
Yes, Judge, good morning.
Good morning, and Mr. Galvan, can you hear me?
Yes, Judge, good morning.
Good morning. Okay, can I please have both of you raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Galvan, yes or no?
Yes.
And Mr. Galvan, yes or no?
Yes.
Okay, you may lower your hands. Mr. Fernandez, you may proceed.
Thank you, Judge. Ms. Galvan, please state your full name for the record.
Monique Peña Galvan.
Okay, and you resided in Texas for 6 months before filing the petition for divorce, right?
Correct.
And also you resided in the county for at least 90 days before, as well.
Correct.
Okay. You're currently married to Jose Luis Galvan Jr.?
Yes.
Okay. Y'all were married on or about December 30th, 2014, is that right?
Yes.
Okay, y'all ceased to live together as a married couple on or about April 18th of 2021?
April 18th. If we lived together?
Y'all ceased living together as a married couple more or less around that time?
Oh, yes. I'm sorry. I misunderstood. Yes, that's correct.
And there's one child of the marriage, Sergio Palomo Galvan?
Wait, I don't think it was 18. It was 2000. It was last year.
Right. It was, I said April 18th, 2021.
Oh, I'm so sorry. Yes, I couldn't hear you. Yes, sir. That's correct.
The child of the marriage is Sergio Palomo Galvan?
Correct.
Okay. He was born on April 26, 2016?
Yes, sir.
Okay. You and Mr. Galvan have signed off on a final decree of divorce?
Yes, sir.
Okay. And in there, you've laid out how you want your property divided?
Yes, sir.
Okay. And also, how you've laid out in there how you want your debt divided?
Yes, sir.
Okay. And you're asking the court for divorce?
Yes, sir.
And as far as the provisions as to child support and child visitation, those are already been determined, and they and we reference that in that's in F 301029. Is that right?
Yes, sir.
Judge, I have no further questions for this witness.
Okay, do you have any questions for Mr. Galvan?
Yes, I do. Mr. Galvan, can you please state your full name for the record?
I am Jose Luis Galvan Jr.
Okay, and you signed off on a document titled Final Decree of Divorce,
Yes, sir.
and you've agreed to the terms contained therein.
Yes, sir.
Nothing further from this witness, Judge, and we'd ask the court to sign the final decree.
Okay, I don't see that a motion to consolidate has been filed. Have you filed that?
Judge, I have not. I did indicate some language about incorporating the provisions into this case.
Yes, and I do see that, and that language is correct. However, the Attorney General's office will flag it if there's not a motion to consolidate. So you do need to file a motion to consolidate and an order granting, consolidating that case into this one. There's not a hearing that's necessary. I will just sign off on it administratively. So, but the other thing that I wanted to point out is that his name is incorrect in that decree. You have it as just Luis Galvan Jr., not Jose Luis.
Okay.
So
make that change, Judge, and then
you'll need for him to sign off on a new decree
no problem, Judge.
with the correct name. And also, did you attach, I didn't see, but an attachment of the order also has to be attached to the decree from the child support case, because you're incorporating it in there. So it has to be attached as Exhibit A.
Okay, so you want me to attach the final order in that other case?
Yes, it has to be attached there, because unless you rewrite and put in there all the terms of the child support, but to avoid that, you just attach it as an exhibit with the language that you have already put in there, which is correct, stating that it's incorporated therein and you're having it continue.
Okay.
But you just need to add it, put it as an exhibit, because what happens is when the AG's office continues with this case, because there's already a case there, they get everything scanned. And so when they get that and they start inputting it into the system in order to credit him correctly, they're going to need that so that his financial activity report form is accurate. And I know those are things that, we don't always think about, but if not, it'll get rejected. And then he could be, it could be that he does not get credited properly. So you want for him to get credited properly.
Understood, Judge. I'll get that decree out to him hopefully later today, and then we'll file the motion to consolidate with the order and have no further business. Judge, may we be excused?
Yes, Mr. Galvan, please be on the lookout for that and just sign it and send it back. And the sooner that you do that, the sooner that I'm able to sign off. All of this will be done administratively, so you won't have to appear again, okay?
Yes, Judge.
So what I will say is that I accept the testimony that has been testified to on the record. And Ms. Galvan, were you requesting a name change?
No, I would like to keep the same last name as my son.
Okay, so then I am approving the testimony as put on the record and granting that relief. Mr. Fernandez will take care of it on his end. As soon as it comes through, I'll sign off on it, okay?
Thank you, Judge.
You're welcome, and I'll go ahead and set a tickler for March 25th just to make sure it's in by then.
Yes, Judge.
All right, if nothing further, once that's all submitted, I'm granting your divorce on the record. However, it's not official until I sign off on it, okay?
Yes, Judge.
All right, y'all have a good day.
You too, ma'am.
You too.
Thank you. Okay, Mr. Ramirez, Attorney Dennis Ramirez.
Yes, Judge, good morning.
Okay, good morning.
I have number 37 on the court's docket.
Okay, let me get that. That's, oh yes, they made an announcement on that, Mr. Ramirez, that they're requesting a bench trial, so they're gonna set an order setting bench trial.
Okay, Judge, thank you very
And
much.
so we'll take care of it administratively.
Thank you, Your Honor. Sorry to waste the court's time. I was in another
Oh.
court and just logged in.
Yes, that's not a problem.
Thank you, Judge. Have a good day.
You too. Okay, Mr. McLaughlin?
Good morning, Your Honor.
morning.
I have several default judgments on the 9:30 docket, and then I have 3 cases on the 11 o'clock docket.
Okay, go ahead.
The
What's your
first-
first case?
Is number 5 on your docket, Portfolio Recovery versus Juan de los Santos?
All right, CL 185433-I, Portfolio Recovery versus Juan de los Santos. Juan de los Santos. Juan de los Santos, Juan de los Santos. Okay, the name being called out 3 times and no response, you may proceed.
In this case, we believe that the defendant had opened up a Walmart credit card with Synchrony Bank. It was opened in November of 2012. He made his last payment on June 5th of 2017. The account was closed and charged off with a balance of $6,771. That amount of damages plus costs to the court. And would ask the court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the service that was returned served and has been on file with the court since October 1st, 2018. The court, and no answer to this date. The court is granting the relief as requested and put on the record. And you did file an order on November 1st, 2019, and that's the order that I'm asking be forwarded to my queue.
Thank you, Your Honor.
Okay, your next case?
Is number 6 on your docket?
Okay, CL 190221-I, TD Auto Finance versus Maria L. Flores. Maria L. Flores. Maria L. Flores. Maria L. Flores. All right, the name being called out 3 times, no response. You may proceed.
In this case, Your Honor, we believe that the defendant had entered into a motor vehicle retail installment contract that was originated on July 26th of 2017. They made their last payment on February 20th of 2018. The vehicle was then subsequently repossessed for non-payment. Deficiency after the auction was $7,517.96. We're seeking that amount in damages plus costs to the court, and would ask the court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff. The defendant was served on January 22nd of 2019, and to my knowledge, no answer has been filed.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the service that was returned, served, and has been on file with the court since January 22nd, 2019. No answer has been filed and the time has lapsed. The court is granting the relief as requested and set forth on the record and is set in further detail in an order that was filed on September 11th, 2019. And that is the order that I'm asking that be forwarded to my queue. Go ahead, your next case.
Is number 7 on your docket?
CL 187198-I, Cascade Capital versus Eugenia Higinia Garza. Eugenia Garza, are you present?
Yes, ma'am, I'm here.
Okay. Hold on. Okay, Eugenia Garza, she is present. Ms. Garza, do you want an opportunity to discuss this with the plaintiff to try and settle the matter?
We can go ahead and go through it with it. I thought this had already been settled. I got a notice a couple of years back where they had said that they were not gonna pursue it. And then I get the mail to present myself, so that's why I'm here.
Okay, so I can't proceed today because you have appeared. And so now their option is either for a bench trial or a summary judgment motion at this time. So what I'm gonna, do you have something to write with?
Me, you're asking me? Yes, I do, Judge.
Mr. McLaughlin, can you please provide your phone number so that Ms. Garza can get that and contact your office?
Yes, Your Honor. For this particular case, the number that she would need to call would be 262-796-7881. And her file number is 332-6133.
Okay, I'm gonna give you an opportunity to contact them to see whether or not you're going to enter an agreement. And then I'm gonna give you a date of April 27th at 9:30. At which time, if you don't reach an agreement, then Mr. McLaughlin, that gives you plenty of time to file any other motions that you need.
Thank you, Your Honor.
Judge,
Yes, go ahead.
do we have an email for Ms. Garza, please?
Oh, yes. Ms. Garza, do you have an email address?
Okay, the only one I have is the one here at work, ma'am. I can give you that one.
Go ahead.
It's h.garza2@lajoyaiz.net.
Okay.
Okay, so I'm assuming that they're going to proceed, Judge?
Not today.
No,
But
not
they're
today,
going,
but
yes, but they are going to, but if you have anything, any documentation stating that they said that they were not going to proceed against you, then I suggest you get that so that you can submit that to them.
no, I don't. I misplaced. I probably can't find it. It's been a while since they did send it, so I just assumed that it was going to be dropped, or I don't know. No, I don't have the documentation, but if they sent it, they should have it. I'm sure they keep their records.
Well, that's assuming because sometimes these notes get, I mean, these things get passed from place to place. So it's not necessarily that that's what they did.
Yes, ma'am, I understand.
Okay. Then Ms. Garza, we'll see you on April the 27th at 9:30 if necessary.
Okay, ma'am, how will I know if it's necessary? Will somebody notify me?
You'll receive an email.
Okay,
But that number that you got, that he gave you, you need to contact them as soon as possible.
yes, ma'am, I will do that.
Okay, thank you.
Thank you, Judge. May I be dismissed?
Yes, ma'am.
Thank you.
Okay.
The
Okay,
next
Mr.
case I have,
McLaughlin,
Your
your
Honor,
next case?
is number 8.
All right, let me see. Number 8, CL 185826-I, Portfolio Recovery versus Maribel Lugo. Is Miss Lugo present? Maribel Lugo? Maribel Lugo? Maribel Lugo. Okay, that name being called out 3 times, no response, you may proceed.
In this case, Your Honor, we believe that the defendant had opened up a Capital One bank credit card in November of 2003. They made their last payment in November of 2015. The account was closed and charged off with a balance of $1,800.95. We're seeking that amount in damages plus costs to the court and would ask the court to take notice of and admit the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff. The defendant was served on this, and service was returned to the court on December 26th of 2018.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the service that was properly done and has been on file for the required amount of time. With the court, no answer has been filed to date. Therefore, the court is granting the relief as requested by the plaintiff and put on the record, and is set forth in further detail in an order that is on file with the court since November 1st, 2019. That is the one that I'll be asking to be forwarded to me. Okay, your next case?
Is number 9 on your docket?
CO 154255-I Portfolio Recovery versus Jessica Mendoza. Jessica Mendoza, are you present? Jessica Mendoza? Jessica Mendoza. All right, you may proceed.
In this case, we believe the defendant had opened up a Home Depot credit card on August 4th of 2005, making their last payment on April 13th of 2012. The account was closed and charged off with a balance of $1,416.32. We're seeking that amount in damages plus costs to the court and would ask the court to take notice of the business records affidavit, the non-military declaration, certificate of last known address, and service was returned to the court on February 5th of 2016.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the service that was returned and has been on file with the court since February the 15th, 2016. The court is, and there is no answer on file, and the required amount of time has passed. The court is granting the relief requested and set forth on the record, and is in further detail in an order that has been on file since January 26, 2017. That's the one that I will be asking be forwarded to me. Okay. Let me see. I think you have a few more cases, Mr. Booth. Let me ask Mr. Bustos what is his case. That way we can continue with you. Mr. Bustos?
Okay. Judge, thank you, Judge. I was in a different court. I came back, Judge. Got number 29, Judge. It's a motion for default judgment. I know it's an older case, Judge. I took over a case. We thought we had fought all the requisite documents, Judge. I know I'm missing some business record affidavits for some of the medicals, Judge. I could have a 30-day extension, Judge. I'll get those medical records. I know I'm having trouble with one because they sold their company, but I'll get those records, Judge.
Okay, April 11th at 9:30.
Thank you, Judge. May I be excused, Your Honor?
You certainly may. Okay, Mr. McLaughlin, your next case?
Okay, I believe we just did number 9 on your docket, correct?
Right.
So the next one is 10.
CO 186488-I Cascade Capital versus Jorge Mendoza. Jorge Mendoza. Jorge Mendoza. Okay, the name being called out 3 times, no response. Go ahead.
In this case, Your Honor, we believe that this is a motor vehicle retail installment contract that the defendant purchased a vehicle on April 16th of 2013. They made their last payment on January 25th of 2014. The vehicle was subsequently repossessed in June of 2014, sold at auction with a deficiency of $8,934.12. We're seeking that amount in damages plus costs to the court, and we're asked court to take notice of the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the service that was returned and has been on file with the court since December 4th, 2018. There is no answer on file and the required amount of time has passed. Therefore, the court is granting the relief as requested and put on the record and set forth in further detail in an order that has been filed on September 10th, 2019. That's the one that I'm asking will be forwarded to my queue.
Thank you, Your Honor. The next case I have is number 11.
CO 174227-I, Capital One versus Cecilia Puentes. Cecilia Puentes. Cecilia Puentes. Cecilia Puentes. Okay, no response. Go ahead.
In this case, Your Honor, we believe that the defendant had opened up a credit account with Capital One Bank in May of 2014, making their last payment on December 13th of 2016. The account was closed and charged off with a balance of $2,291.86. We're seeking that amount in damages plus costs to the court, and we'll ask court to take notice of the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff. And also that the in the registry of actions, I do not see. I see the service citation issued, but I don't see it returned.
You're correct. So I'll have to give you a reset on that, and your order setting hearing on the default judgment will also have to be refiled. And that'll be, because it needs to go back out to the defendant, and that'll be set for April 27th at 9:30.
Okay. The next one I have is number 13, Your Honor.
Okay, CL 196537-I Citibank versus Tomas Rangel. Okay. Name being called out 3 times and no response.
In this, Your Honor, I believe that, so we want to set a date for summary judgment, but there may be an issue with the notice that we sent to the defendant, so I would request that April 27th date in this case.
Okay. And that'll be at 9:30. That's fine. April 27th at 9:30. Okay.
Thank you, Your Honor. Let's see, the next case I have is number 26 on your docket.
CL 194936-I Portfolio Recovery versus Rosalinda Alanis. Okay, you may proceed.
In this case, Your Honor, we believe the defendant had opened up a Citibank Sears credit card in November of 2014, making their last payment in April of 2018. The account was closed and charged off with a balance of $3,027.12. We're seeking that amount in damages plus costs to the court. We'd ask the court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff. The defendant service was returned on October 15th of 2019. I believe it was by substitute service, and no answer has been filed.
Okay. The court is taking judicial notice of all the documents in the court's file, specifically the service that was properly done and returned and has been on file with the court since October 15th, 2019. The court sees that there is no answer on file and the required amount of time has already passed. The court is granting the relief as requested and put on the record, set forth in further detail in an order that was filed and been with the court since November 20th, 2019. That is the one that I'm asking be forwarded to my queue. Okay. Your next.
The next is number 28 on your docket.
CL 174112-I Portfolio Recovery versus Gabriel Cadena. Gabriel Cadena. Okay, the name being called out 3 times, no response. Go ahead.
In this case, Your Honor, we believe the defendant had opened up a Citibank My Best Buy credit card on November 23rd of 2010, making their last payment on August 18th of 2018. The account was closed and charged off with a balance of $3,668.07. We're seeking that amount in damages plus costs of the court, and would ask the court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff. The defendant's service was returned on October 27th of 2017 with no answer filed.
Okay. The court is taking judicial notice of all the documents in the court's file, specifically that the service has been on file with the court since October 27th, 2017. No answer has been filed and the required amount of time has passed. The court is granting the relief as requested and put on the record and set forth in further detail in an order filed on November 4th, 2019. And that's the one that I'll ask be forwarded to my queue. Your next case,
Is number 30 on your docket?
CL 194162-I Cascade Capital versus Lydia Lidia Martinez. Lydia Martinez, are you present? Lydia Martinez. Lydia Martinez, okay, the name being called out 3 times, no response. You may proceed.
In this case, Your Honor, this is a motor vehicle retail installment contract where the defendant purchased a vehicle on November 16th of 2013. They made their last payment on February 18th of 2016. The account was subsequently closed, charged off. The vehicle was repossessed in June of 2016, sold with a deficiency of $6,333.66. We're seeking that amount of damages plus costs of the court. Would ask the court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff. The defendant was served. Service was returned on August 18th of 2019, and no answer was filed.
Okay, the court is taking judicial notice of all the documents in the court's file. Specifically, the service that was returned and has been on file with the court since August 19th, 2019. No answer has been filed since that date, and the required amount of time has passed. The court is granting the relief as requested and put on the record, and is set forth in further detail in the order that was filed on November 4th, 2019. And that is the one that I'm asking be forwarded to my queue.
The next one I have in Your Honor is number 31.
CL 173893-I Portfolio Recovery versus Rosa Mercado. The name being called out 3 times, no response. You may proceed.
In this case, Your Honor, we believe that the defendant had opened up a Sam's Club credit card with Synchrony Bank in June of 2013, making their last payment in July of 2015. The account was closed and charged off with a balance of $1,713.38. We're seeking that amount of damages plus costs of the court, and we're asking the court to take notice of the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff. Service was returned in this case on November 16th of 2017 with no answer filed.
Okay, the court is taking judicial notice of all the documents in the court's file. Specifically, the service that was returned has been on file with the court since November 16th, 2017. No answer has been filed. The required amount of time has passed. The court is granting the relief requested and put on the record that is set forth in further detail in an order that was filed on February the 26th, 2019. And that's the one that I'll ask to be forwarded to my queue.
Thank you, Your Honor. The next case I have is number 32 on your docket.
CL 164689-I Portfolio Recovery Associates versus Osvaldo Valdez. Osvaldo Valdez. The name being called out 3 times, no response. What is your announcement?
In this case, Your Honor, we're seeking a default judgment. The defendant had opened up, again, a Sam's Club credit card with Synchrony Bank in July of 2006, making their last payment on July 11th of 2015. The account was closed and charged off with a balance of $2,361.31. We're seeking that amount in damages plus costs of the court. Would ask the court to take notice of the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff. The defendant's service was returned on December 23rd of 2016 with no answer filed.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the service that was returned on December 23rd, 2016. It has been on file for the required amount of time. No answer has been filed and the time has lapsed. The court is granting the relief as requested and put on the record, set forth in further detail in an order that was filed on May 6, 2020. And that's the one that I'll ask be forwarded to my queue.
The next cases I have on your docket, Your Honor, are 1, 2, and 3 on the 11 o'clock docket.
Okay. Well, we have to wait for just about a couple more minutes. Let me see who these ladies are, and then I'll take you up.
Okay, thank you.
All right, okay. Blanca Ferrer.
Yes, ma'am.
Okay, and what are you here for, ma'am?
It's for a divorce as well.
A divorce.
Number 23, Your Honor.
Okay. Is Mr. Mercado going to be present?
No, ma'am, I don't think so.
Okay, let me go ahead and look up your case to make sure that everything is properly filed.
Okay, ma'am.
Okay, ma'am, why is it that you filed a motion for citation by posting? You don't know where your husband is?
At first, when I was trying to contact him, I didn't know. Like, he was supposedly working. I tried calling his dad and his mom.
Okay.
And they said he was working, but not exactly. They didn't know exactly where.
And now do you know where he's at?
No, I don't know.
Okay. Because the thing is that since you asked for a citation by posting, you didn't have an order setting hearing on it. So I returned your order on that citation by posting. So I'm not sure why you filed an order setting the final hearing, because you have not, oh, wait a minute. Who filed the waiver of service? I see a waiver of service was filed. So did you find him?
I didn't find him. I contacted him by my mom's side. So he went to sign the divorce at the lady I contacted.
Okay, so then he filed a waiver of service back on December 17, 2021. Okay,
Yes.
hold on. Do you all have any children?
No, ma'am, we don't.
Okay. Hold on. Okay, so he did file a waiver of service, so your citation by posting is not necessary. However, in that waiver of service, he did say that he did not want the divorce to be taken up unless he had signed the divorce decree. So do you have a copy of the waiver of service that he filed?
I don't have it with me, but I can get it.
Well, okay, so what I would do is you are entitled to a copy of that waiver of service. Do you have something to write with?
Yes, ma'am.
All right. His phone number is 956-603-7555. And if you need the copy of the waiver of service, you can also come to the courthouse and get that. But contact him and tell him to sign your divorce decree and then refile it with the signature of both you and him.
Okay,
And let me go ahead and look at your decree real quick.
okay, ma'am.
So you and him do not have any children and you do not have a home, is that correct?
Yes, correct,
And you don't have any other real estate property, is that correct?
correct, ma'am.
And is your vehicle under your name?
No, ma'am.
Is it under his name?
Yes,
Okay. Did you all agree that you're gonna keep that vehicle?
yes.
And have you been making payments on that vehicle?
No, the vehicle, he has it.
Okay, so he's driving a vehicle that's under his name?
Yes,
And
it's
you're
under his.
driving a vehicle that's under whose name? A friend
No.
or it doesn't matter?
I don't have a vehicle.
Oh, you don't have a car?
No, ma'am.
Okay, but he has a car that's under his name?
Yes, ma'am.
Okay, and there's not anything else that you all own?
No, ma'am.
Okay, go ahead and have him sign the decree. And that way both of you sign it. When it's sent, you're not gonna need a hearing because you don't have any kids and you don't have any community property. I'll go ahead and tell my court coordinator that she can forward it to me for my signature, but it does need his signature.
Okay, so we need to sign both the decree and resend it?
Yes,
Okay, ma'am.
and then I'll sign off on it.
Okay, ma'am.
All right?
Yes, ma'am.
Okay, thank you.
Thank you.
Okay. ¿Qué es su nombre, señora, con aquí el usuario de Zoom aquí? ¿Qué es su nombre?
Hello,
Yes, what's your name?
Anabel Pérez de Hinojosa.
Okay, and are you English speaking or Spanish speaking? ¿Habla inglés o español?
Español, pero aquí tengo a alguien que me puede decir si me hablan en inglés.
Okay, un momento. Okay. Let me look up the case. Ok, usted ya tiene un caso con el Attorney General donde está recibiendo pagos para child support.
No, mi hijo ya tiene 18 años.
Ok, porque aquí puso usted que tiene un hijo, Daniel Adán Hinojosa.
Sí, correcto.
Pero ¿cuántos años tiene él?
18.
¿Y ya graduó?
No, todavía no.
¿Todavía está en la escuela?
Sí.
Ok. ¿Y está Daniel en Medicaid?
Tiene chip.
Ok. ¿Y usted habla con su esposo Luz Hinojosa?
No.
Ok. Lo que no puedo decirle, mira, lo que pasa es como su hijo está en CHIPS, en la oficina del Attorney General, ellos tienen el derecho a ver si ellos quieren proceder en este caso, ¿ok? Pero como su hijo ya ¿va a graduar su hijo en mayo?
Pues sí.
Pero va a graduar este año.
Pues si termina lo que le falta de horas, sí.
Ok. Porque lo que pasa es, mira, si usted no va a querer, si no quiere que se meta el Attorney General y va a tener esa situación, entonces es mejor que usted se espere hasta que gradúe su hijo, porque ya va a graduar en mayo, si Dios quiere.
Ajá.
¿Ok?
Porque su papá le da dinero, le pone en la tarjeta.
Sí.
Por eso yo
Pero
no pido nada.
No, yo sé, pero lo que pasa es que usted no puede decir que no quiere child support porque está en chips. So el señor tiene que pagar dinero al Estado porque está el niño en chips. So quiera o no quiera, él lo tiene que hacer.
Okay.
So por eso digo yo que es mejor si usted se espera hasta que el niño vaya a graduar en estos 2-3 meses.
Es que, pues en eso estamos porque como supuestamente me dice él que va a acabar y luego me dice que se va a ir con su papá y pues ahorita no sé qué es lo que...
Entonces usted tiene que hacer cita con la oficina del Attorney General que está en la calle Jackson en FAR para preguntarles a ellos si se van a meter en su causa porque como tiene chips usted.
Okay.
So le voy a dar otra cita, le voy a dar tiempo para hacer eso y va a regresar usted el día 27 de abril a las 9:30.
Okay.
Ms. Rivera, do you already have an email address for her?
Judge, I don't believe so.
Okay, Ms. Pérez, ¿me puede dar su correo electrónico, por favor?
No, ¿cuál es mi correo electrónico? No. Aquí, mami. Permíteme, ma'am.
Okay.
Es que lo estoy buscando.
Está bien.
Sí. Permíteme, es que como tengo dos y los tengo que buscar. Permíteme.
Judge, I misspoke. I do have an Annabelle Hinojosa 2020. I'm sorry, Annabelle Hinojosa 2121 at iCloud.com.
Oh, sí, correcto, ese es, señorita.
Okay. All right, well then, entonces usted va a regresar el día 27 de abril a las 9:30, pero tiene que ir a visitar a ellos primero, ¿ok?
Sí, está bien.
All right.
Y
Bueno.
ya con eso ya después, ahí me va a decir usted del divorcio.
Si ellos no van a meterse, ya se puede divorciar. Bueno. We lost her. Okay, Mr. Latzman, what case do you have?
Good morning, Your Honor. I am here on docket number 25, which is the Mendoza versus Standard Guarantee Insurance Company. I just put in an appearance this morning to cover for the attorney, Brad Eakin, who was originally assigned on this case. This was plaintiff's motion to mediate. We reached an agreement off the record before the hearing began that we were going to pass today's motion. I just wanted to be here just in case it, in fact, Mr. Gonzalez, the plaintiff's lawyer, turned up and wanted to go through, but seeing that there isn't anybody, I hadn't seen the motion come through, but we just want to make sure that we were here if it got called.
Okay, no, you're fine. So then you all have already reached an agreement and
Se me cortó.
Sí, ahorita.
Ah, okay.
And so then, what is your next step? Y'all are going to mediate this, and how much time? Do you know?
It sounded like the parties were going to agree to try to get something out 90 days, given the backlog of mediators scheduling right now. So that's what it was looking like.
Okay, let's have a status hearing on June the 8th. No, I'm sorry, June the 1st. Let's do June the 1st. And that'll be at 9:30. And let's see how much progress y'all have by then.
Super. Thanks so much, Your Honor.
Okay, take care.
Thank you. You too. Bye-bye.
Ok, Ms. Pérez, está bien, ya tenemos su correo electrónico, usted va a tener que ir a esa oficina. Entonces, va a regresar el día 27 de abril y si ellos se van a meter, entonces ellos tienen ese tiempo para meter los papeles que ellos necesitan. Si no se van a meter, entonces es posible que vamos a poder proceder ese día, ¿ok?
Ok.
Bueno, muchas
Está bien.
gracias. Los
Gracias
vemos
a
en
usted.
ese tiempo.
Ok, gracias.
De nada. Okay, Mr. McLaughlin, we're going to call CL 153946-I, Portfolio Recovery versus Vanessa Grimaldo, Vanessa VENESSA. And I do
Okay.
not have anybody left, and there's no one in the reading room and nobody else on the screen. So Vanessa Grimaldo, that name being called out 3 times, no response. What is your announcement?
So my concern right now is notice to defendant because I have something saying that the order for the hearing was sent out on the 18th of this month, and that was not enough notice for the defendant.
Judge, if I may,
Go ahead.
Your Honor, the order setting hearing was filed on the 18th. However, the court did not sign it due to the short amount of time that would be. There wasn't enough notice for the defendant.
Okay, go ahead and file an order resetting hearing and we'll get that reset.
Okay, thank you, Your Honor.
All right, and then we have CL 21473-I, TD Auto Finance versus Elvira Rodriguez, the name being called out 3 times, no response. You may proceed.
In this case, Your Honor, we believe that the defendant entered into a motor vehicle retail installment contract on December 5th of 2017, making their last payment on August 29th of 2018. The vehicle was subsequently repossessed with a deficiency of $16,444.09. We're seeking that amount in damages plus costs of the court. Would ask court to take notice of the business records affidavit, the non-military declaration and certificate of last known address, and issue judgment for the plaintiff. The defendant was served on March 20th of 2020, and they, I believe, have proper notice of today's bench trial.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that the service was returned on March 20th, 2020. Defendant did file a pro se answer on March 31st, 2021, within the allowed amount of time. Defendant also received proper notice of today's bench trial setting. Since this is a bench trial, then based on what has been put on the record by the plaintiff, the court finds in favor of the plaintiff. And an order does need to be submitted, Mr. McLaughlin, and I'll give you till March 25th to submit it.
Thank you, Your Honor.
Okay, and then you have CL 192382-I, Cons Appliance versus Gelacio Tavera, GELACIO Tavera. Mr. Tavera, Gelacio Tavera, name being called out 3 times and no response. You may proceed.
In this case, Your Honor, we believe that the defendant had entered into a contract, a credit account with Con Appliances on May 9th of 2012, making their last payment on August 18th of 2015. The account was subsequently closed and charged off with a balance of correction, Your Honor. I apologize. They opened the account on August 18th of 2015. They made their last payment on August 7th of 2016. Service was on May 9th of 2019. The account was closed and charged off with a balance of $1,509.87. We're seeking that amount in damages plus costs of court and would ask the court to take notice of the business records affidavit, the non-military declaration, and certificate of last known address, and issue judgment for the plaintiff.
Okay. Now, on this one, it's the same thing. The order setting hearing was not filed until February the 22nd. And the order setting hearing was not signed due to that. So there was not notice to the defendant. I do need you to file an order resetting hearing on this one as well.
Thank you, Your Honor. We will do that.
Okay, do you have number 4 on the docket? Did we do that one?
No, I do not have. Let me just verify that I do not have. Yes, actually, I do have that case.
Okay, CL 154255-I Portfolio Recovery versus Jessica Mendoza. Jessica Mendoza, name being called out 3 times and no response. You may proceed.
In this case, Your Honor, we believe that the defendant had opened up a Home Depot credit card with her last payment being April 13th of 2012. The account was subsequently closed and charged off. We're seeking a default judgment in this case in the amount of $1,416.32. We're asking the court to take notice of the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the service that was returned and has been on file with the court since February 15, 2016. No answer was on file. The required amount of time has lapsed. The court is granting the relief as requested and put on the record by plaintiff and set forth in more detail in an order filed with the court on January 26, 2017. And that's the one that I'll ask be forwarded to my queue.
Thank you, Your Honor.
And let me just, okay. That should be all your cases, correct?
I believe that is all my cases. There was somebody else for a few default judgments that I wasn't handling.
Okay, yes, those already got taken care of.
All right, thank you.
Thank you, have a good day.
You too.
Okay, Mr. Vargas, let me recall your case, CL 186395-I. Mr. Alvarez did make a announcement stating that there's a DCC that you all will be having on March the 11th. And so
okay.
he'll be attending that, and he filed his notice of appearance as well.
I just noticed, I didn't know there was opposing counsel on this, but great.
They were just retained.
Okay.
Okay, do you have his contact info? Did you receive the notice of appearance?
No, I haven't gone through my emails today, Judge. It looks
Okay.
like it was just filed today.
Yes, it was. Okay. All right, so then I'll give you all an opportunity to do that, and then we'll see how y'all proceed.
Okay, thank you, Judge.
All right, thank you. Have a good one.
Have a good night.
Okay, number 41 on the court's docket, CL 144275-I. Did anybody call in on this one?
No, Judge, actually the notice was returned on the defendant, but there was no email for the plaintiff. So nobody appeared or showed up, Judge, or filed anything, I'm sorry.
Okay, let's go ahead and do a drop. Set it up for a DWAP. Okay, that concludes this morning's docket.